There was never an ultrasound. Why would there be? Why would there be? Good morning from the internet, where your cesspool is my jacuzzi. Last night, some more documents dropped in the Clayton Echard versus Laura Owens paternity scandal case. I've been saying it's kind of funny whenever I read Laura's attorney's filings, because he, at least at one point, had referenced Donald Trump, and I constantly find myself, in response to their antics, thinking, but her emails, or lock her up. Now, this is Greg Woodnick's response/objection to petitioner's motion for judgment on the pleadings and renewed motion to dismiss. If you're like me and you don't want to read 50 plus pages in the morning, I'm going to try to boil it down a little bit here. I'm not going to read it word for word, but I'm going to read a lot of it, and I'm going to try to make sure I hit the important points. In this first part here, they're arguing that Laura has presented a false choice fallacy in an attempt to artificially limit both the scope of the pleadings and the court's authority. They're arguing that Rule 26 is not the exclusive source of the court's authority to award attorney's fees, and also it doesn't govern the substantive claims for relief. So they're saying that Laura knows, or at least should know, that her Rule 26 or dismiss the action dichotomy is both frivolous and misleading, which seems to be a theme here, but yeah. Even if Laura's... Butter objects on the grounds that I should be giving him treats and not reading this motion. Say hi. Hi, everybody. Even if Laura's arguments interpreting Rule 26 were correct, sorry, that's funny, the net result on the posture of the case would be absolutely no change at all from the existing trial scheduled on the merits of the pleadings. Accordingly, her prayer for relief, improperly styled as a motion for judgment on the pleadings and renewed motion to dismiss, was already moot before it was even filed because Rule 26 is not at issue. The motion has no bearing on the resolution of this case. As detailed in prior filings, by withdrawing his Rule 26 motion, Clayton hoped to avoid Laura's noxious agenda of papering the court with dozens of pages of meaningless debate on this topic, but Laura appears determined to have this purely theoretical argument regardless. Clayton provided written notice as required by Rule 26, Arizona Rules of Family Law Procedure, through emails and filings. As addressed in depth in his motion to withdraw, Clayton's motion for leave to amend provided notice of his intent to seek sanctions against Laura and cited Rule 26. The court granted leave to amend and accepted the amended response, also citing Rule 26 and indicating an intent to seek sanctions against Laura on January 25th, 2024. It then goes on to say, more than 10 days after being notified of Clayton's intent to seek Rule 26 sanctions via the motion for leave to amend, Laura moved to dismiss her petition because she was, cryptically, no longer pregnant. Then they move on to respond to the motion for judgment on the pleadings. Here they're saying, on January 25th, 2024, the court deliberately indicated it was not dismissing the action because Clayton is entitled to resolution of his claims for a finding of non-paternity, attorney's fees, and sanctions. Even if this court finds Clayton did not provide proper notice, Rule 26 is just one avenue for sanctions. Rule 26 is a carryover from the Rules of Civil Procedure as a remedial measure for frivolous claims and filings during the pendency of the proceedings, not a mechanism for defeating substantive statutory claims for relief as Laura suggests. Regarding the safe harbor notice provision, that portion of Rule 26 permits a party to correct or withdraw a filing within the notice period, but it is not an absolute right to withdraw the entire action. Like, I'm not a lawyer, but reading this, I'm kind of like, what was David doing? As previously addressed in his motion to withdraw, if Laura's theory that she was denied an absolute right to withdraw her entire action were true, no party would ever move for Rule 26 sanctions. Under Laura's view, that would hand the other side a monopoly-style get-out-of-jail-free card to avoid consequences regardless of the extent of the frivolous, inflammatory, and impermissible claims in their filings or the outrageousness of their conduct after filing. Here he's got a footnote, okay. In the footnote he's saying Laura's conduct in this action clearly fall within all of these categories. Okay, in this footnote he's saying that Laura's conduct in this action and the other protective order proceedings clearly fall within all of these categories, as Laura allegedly frivolously brought the underlying action alleging she was pregnant after non-intercourse with Clayton's twins, and continued to perpetuate alleged fraud upon the court by submitting she's so stupid. By submitting knowingly fabricated medical records. Sorry, it's Laura has behaved inflammatorily by continuing to present herself as 24 weeks pregnant with boy and girl twins and repeatedly testifying to actively being seen by physicians who have since disclaimed ever seeing Laura as a patient and by engaging in toxic diatribe on Twitter and blog posts, including attempting to intimidate witnesses. I mean, how did they think that was a good idea, dude? Even if he were just a PR person, even if he was just doing PR, like, this was a terrible strategy. Nearly all of Laura's filings have contained legally impermissible claims. For limited example, Laura's motion to communicate and this motion for judgment on the pleadings. Lastly, her conduct in this litigation has been extremely outrageous, to wit, admittedly fabricating medical records, baselessly accusing others of fabricating the records she herself tampered with, and allegedly committing perjury in multiple filings, and in statements before this court. Notably, Laura bizarrely appears to continue to allege the sonogram that she admitted to doctoring and that did not originate in either location she alleged is legitimate, despite mountains of evidence to the contrary. Even assuming in arguendo that Laura was entitled to a 10-day miracle cure period to undo her past bad acts, she has already been given those opportunities and did not accept them. Yes, she moved to dismiss her petition eventually, but it was well after 10 days from Clayton's motion for leave to amend, and was denied because Clayton has material statutory claims entitled to a resolution on the merits. There is simply no reason to believe there was ever a time that Laura would have voluntarily withdrawn her claims, even if she was given that opportunity with no strings attached. Instead, her antics continued, including alleging that a prior victim fabricated her medical records, which she now appears to be claiming she does not remember, creating the allegedly fabricated medical records. Moreover, Clayton even offered several times for Laura to walk away from this litigation if she apologized and admitted that she was never pregnant by him with twins. Laura rejected every effort to resolve this matter and even engaged in overt efforts to intimidate witnesses into not participating in this process by threatening to have them arrested. Then, she conveniently failed to mention in her recent reply in support of Laura's motion in Lamine that she has been in contact with Mr. Maricini and his attorney, and he has clearly indicated his desire to have his voice heard at trial. Moreover, Laura via counsel stated, "I am happy to discuss settlement, but I also need to be honest. When Laura prevails in this case," sorry, that's the stupidest thing. Okay. When Laura prevails in this case, she is going to sue Clayton and many other people for defamation and other torts. Okay. We can certainly avoid that if you want, but it's going to involve someone writing a very large check to Laura. If you offered $1 million right now, I'd advise her to reject that offer. That is adorable. Again, even if Laura had attempted to withdraw from the action entirely, that was only subject to the court's approval and Clayton's right to object consistent with Rule 46. A harmonious reading of Rules 46 and 26 tells us that a pleading can be withdrawn voluntarily before a responsive pleading is filed, but after a responsive pleading is filed, it can only be withdrawn with the court's permission after consideration of the opposing party's right to have their responsive claims and counterclaims adjudicated. Laura has already tried this and was denied by this court. Well, we've seen how Laura handles denials. Send another email, send another motion, try again. Notwithstanding all of this, a motion for judgment on the pleadings makes absolutely no sense in this case's context. Judgment on the pleadings would require the court to find Clayton's allegations in the response that Laura was never pregnant with his twins as true, and therefore find her subsequent representations to 3 different judges under oath were maliciously fraudulent. Even assuming this court agrees with Laura's highly contested interpretation of Rule 26, the parties would still be heading to trial. As Laura has repeatedly indicated in her filings, emails, blog posts, and tweets, she has no interest in conceding what Clayton has alleged since the beginning, that she was never pregnant by Clayton with twins after their non-intercourse. Interpreting Rule 26 and the safe harbor period as a necessary precedent condition for the court to sanction a party under any other source of authority at law or in equity would be the most absurd result imaginable. The court cannot read a rule as requiring an absurd result unless that is the only plausible reading, and that is clearly not the situation presented here. Oral argument is an unnecessary and expensive distraction on the eve of trial. Efforts to delay and avoid this trial are over the top. This is a bench trial that is set to take place in less than a month. If Laura desires to use this motion or her limited time at trial to argue about procedural rules that have no bearing on the substantive issues of this case, that is her prerogative and should count against her limited time. Clayton should not be forced to participate in such futility because his analysis of the Rule 26 issue has been thoroughly explained on the record twice. This is the Conor McGregor litigation that was promised by Laura's counsel and is only exemplified by the personal tweets, blogs, and what this court may see as efforts to intimidate for no reason other than to dissuade just resolution of claims. It needs to stop. Clayton exhaustively outlined in his motion to withdraw most, if not all, of the factual and legal bases outlined in this response. Laura did not even reply to Clayton's motion. Instead, she agreed with it and filed a notice of non-objection. The withdrawal was filed to avoid more of the toxic litigation, threats of appeals and personal sanctions, and bullying efforts. It did not work. Still, Laura seeks yet another impossible form of relief in a motion designed to increase expenses and avoid trial. Clayton requests that he be permitted to submit a China doll affidavit that includes all of the prior unwarranted and legally inappropriate filings he has had to defend himself against in this litigation. Wherefore, Clayton respectfully requests the court deny the motion for judgment on the pleadings and renewed motion to dismiss, grant Clayton leave to submit a China doll affidavit, and grant other relief this court deems just and proper. Now we get into the exhibits. The first exhibit is just a document we've already seen. It's the motion to withdraw a motion for sanctions pursuant to Rule 26, so I'm not going to go over that. Okay, these are some of David's fun little love note emails that he sends, and I think we have already seen most of this. He's saying if Mike comes within 100 yards of Laura without being compelled to appear by subpoena, then he will risk arrest and prosecution for violating the restraining order. And of course, they've attached a copy of Mike's subpoena. Here they've attached a copy of the email Mike Maricini sent to David Gingras in response to David Gingras' interesting kind of behaviors towards him. We've already seen that recently, again, and it's been covered pretty extensively, so I'm not going to read through all this right now. This is David talking to Greg Woodnick about Mike, saying he's apparently unhappy about something I tweeted yesterday, which I removed after seeing his email. This doesn't seem fair. Laura is being attacked relentlessly on a daily, virtually constant basis by people on Clayton's side, but somehow if I say or do anything to respond, this is somehow deemed outrageous. It's really frustrating. There are two sides to the story here, and one seems to be monopolizing the narrative, often with less than total candor. Okay. Again, this is not any sort of criticism directed at you. It's just hard when I'm dealing with people who demand that only their side of the story can be told. That's clearly not the case here. I mean, people have been asking him to explain more of their side. It's just that he won't answer those questions because it looks bad. Also, I'm sure his client wouldn't want him answering those questions truthfully, like, what about the Planned Parenthood ultrasound? Okay, so this is David responding to Greg, and he's commenting back on like some of the things that Greg had sent him. Greg was asking about trial time, saying he would streamline his presentation to fit into their hour. Laura invoked Rule 2 with one of her prior lawyers. Maybe we can maximize our court time if we stipulate to proceeding without Rule 2. I think that also helps keep costs down. Oh, okay, so there's no way David's going to go for that. In response, David says, I always favor streamlining and simplification, but we need to follow the rules of evidence, so I won't agree to waive Rule 2. That just isn't appropriate in light of the allegations here. There is way too much inappropriate stuff. Okay. There's way too much inappropriate stuff being brought in by your side, so we need the evidentiary rules to help narrow things down. That is cute. Here, Greg tells David what the witnesses are planning to talk about. Time permitting and consistent with the disclosure, they will testify that they experienced false pregnancy claims, altered medical records, suicidal threats of breakups, behavior with their families and abortions, contingent on relationship contracts, etc. David responds that he's going to file a motion in limine to preclude the testimony. Here, Greg is talking about the experts. I forwarded your experts' drafts to our experts. I'm a little confused by your expert report, and while ours, forthcoming, will certainly not align and was delayed because we are giving Planned Parenthood a second chance at providing the ultrasound. I don't think your doctor's testimony, if accepted by the court, addresses the fundamental problem of your client's behavior in the litigation. That's definitely true. Parenthetically, I would point out that your theory about weight gain is quickly refuted by your client's own medical records. Per her Banner record, she weighed 121 pounds on June 1st, 2023. Okay. So here, David says he's going to bring a motion to exclude your experts based on 702/Daubert and relevance. Side note, your third disclosure statement says Dr. Deans is going to testify that HCG tests were never dispositive of pregnancy. Assuming she says this, which is hardly a contested issue, I think it's important to remind you that you were applying exactly the wrong standard here. The only remaining issue is whether Laura should be sanctioned for bringing a claim she knew was false. While you were going to lose that argument for other reasons, to obtain sanctions, you seem to believe that Laura has some obligation to show to a 100.000, is that what you meant to put there, David? To show to a, we'll say 100% degree of medical certainty that she was pregnant. That is what the JFC crew has been claiming for weeks. Okay, well, you're talking to Clayton's lawyer. You're not talking to the internet right now, so maybe chill the fuck out. That is exactly backwards. Laura simply has to show she had some reason to think she might be pregnant. If she had that basis, she cannot be sanctioned, even if her belief was wrong. At no point is she obligated to establish the pregnancy was confirmed in some dispositive manner, whatever that even means. Maybe Google it, dude. This is just another reason why I will probably move to exclude Dr. Dean's testimony about HCG not being dispositive. Who cares? That is simply not relevant to any issue in this case. Okay. Honestly, I'm guessing Dr. Deans would agree that a positive HCG test does give a woman a reason to believe she probably was pregnant, which would make her a strong witness for Laura's side. I feel like maybe you could go that route. Maybe. If your client hadn't also pretended she got ultrasounds and saw certain doctors. Either she's lying about that or she wasn't. And so far, it seems she was lying. Here is mentioning the motion for judgment on the pleadings and intention for David to file sanctions against Greg personally. Greg says, if this is how you choose to litigate and to relitigate things that have already been addressed and denied, then a phone call to discuss is not going to impact anything. It will be more posturing, and I don't think it is helping our clients. File what you must, and we will respond in kind. David says, I don't understand what you mean by this. Things that have already been addressed and denied. What do you mean, bro? Does he read the stuff that comes out on the docket? I think you must be referring to the fact that Laura's prior counsel asked the court to dismiss the case, and then the judge apparently granted that and changed her mind? Changed her mind? What do you mean? Right, David's saying basically his motion is going to argue that they can't get sanctions because Greg didn't follow the rules. I don't believe that issue was fully raised before, which is why I'm going to raise it now. Have you not harped this shit to death already? Here Greg is talking about David's request to meet and confer. Greg says the purpose of a meet and confer is to discuss possible resolution of the issues. If you have a proposed settlement you would like to discuss, I'm happy to coordinate the call, but I am not interested in the scorched earth Conor McGregor stuff. You apologized previously, but reverted to the same behavior online via Twitter and your blog. If you really think the call would be productive, I am happy to coordinate it, but your mind seems very made up, at least from your blogs and whatnot. If you think a call would change your perspective about what you're going to file, I will find time to talk with you this afternoon. David has a really impassioned response to this. Did Dave Neal ever share that long email I sent? If you haven't seen it, let me know and I'm happy to share it with you. The point is you misunderstood what I meant about Conor McGregor. As I explained to Dave Neal, I have been involved in many cases that were much more contentious than this one. And in many of those cases, opposing counsel ended up losing their licenses, and in more than one case, the lawyers ended up in jail. Can you please provide examples, sir? Not for them. I mean, you don't have to do it in here, but I mean, since you like to blog so much, could you maybe, put that out there? The Conor McGregor reference simply means I've been dragged into a lot of really nasty fights, never by my choice. Yeah, sure. And in many of those fights, my adversaries have ended up self-destructing while I'm still here standing. That's what Conor McGregor means to me. It was never a suggestion that I enjoy violent confrontation or that I am out to gratuitously hurt anyone. My point was to say that I'm a veteran of many tough battles, and while I would prefer to avoid messy conflicts, I am not afraid of going there if given no other choice. I'm not going to read the rest of this because it's kind of redundant to shit he's already said, and he's not really adding anything helpful. Now that I fully understand the case from Laura's side, I would really find it helpful if you could give me additional detail from Clayton's side, especially with regard to this claim that Laura faked pregnancies with other men. Can you not read? Here he's giving Laura's account of her relationship with Greg. She had a brief relationship with Gillespie. I think she said they had sex twice and went on roughly 6 dates over a period of a few weeks. Okay, can anyone find a contradiction there? Has she said elsewhere that it was a different timeline? Because if so, let's point that out. Laura tested positive for pregnancy. Gillespie asked her to terminate the pregnancy medically, which she did about 4 weeks later by taking pills in Gillespie's presence. Well, wasn't she sending him texts upset that he wouldn't be with her when she took the pills because it was making her feel sick or something? Something along those lines. Somebody help me point that out. According to Laura, that is the entire story aside from later litigation, which went nowhere. There was never an ultrasound. Why would there be? Why would there be? And there were basically no other medical records involved other than the initial pregnancy test and the later medical abortion. Assuming Laura has accurately communicated the above facts, big assumption there, I'm guessing that Gillespie's only basis for claiming that Laura faked the pregnancy is because, what? He just doesn't think she actually got pregnant? Pure speculation like that is clearly inadmissible, and if you tried to call Gillespie as a witness and ask him whether he thinks Laura faked being pregnant with him, I'd object due to a lack of foundation and calls for speculation. After this many years of legal practice, you should know this by now. You can't call a witness and ask them to guess about whether something happened. The witness must first prove they have personal knowledge of the matter in question. I don't think that's going to be a problem. I see no basis to establish that Gillespie has personal knowledge of Laura not being pregnant. Greg Woodnick is saying, I know Laura wants this to be over. Candidly, Clayton does too, but that requires her acknowledging how dishonest her behavior has been. I only speak for Clayton, but he does not seem interested in more litigation, both because Laura is probably judgment-proof and because he has wanted the same thing since day one. He does not believe in the pregnancy as they did not have sex, and for all of the myriad of reasons you already know, including the nearly identical stories from 3 other men. All Clayton has ever wanted is an acknowledgement by Laura that she has a pattern of lying about pregnancy to force relationships with guys who have rejected her, even accepting, which we don't, that she was pregnant without intercourse, and your expert's conclusion that she was pregnant with Clayton's twin children without any DNA testing and with a fabricated ultrasound. It does not change what happened since her alleged miscarriage or her conduct predating this litigation. This ends either with trial in June or with Laura coming clean. This is her out. David's brilliant response to that is, I'm happy to discuss settlement, but I need to be honest. That's where he talks about the $1 million things he would advise Laura to reject it. That is incredibly fucking stupid. Here, David mentions his witnesses are 1, Laura, 2, Clayton, 3, Laura's mom, and 4, Dr. Medchill, a provider who has never seen Laura, to my knowledge. Okay. And easier, but honestly, I don't know if I did a great job of that, because it's just so hard to kind of unpack all of that shit, but that's all for now. I will catch you guys later because I gotta clock into my day job now.